Thank you, everyone. And I want to first welcome everyone to this August gathering because this program has become so relevant and important in these times uh, when we are discussing about data privacy in the digital era. A lot of incidents are being reported on daily basis. Court matters are happening. Privacy policy and other data privacy issues are coming up. What could be the best time to have this program? So once again, welcome to all on the program on data privacy in the digital era, whether it is a myth or a reality. Uh, Secondly, we are also blessed with the august presence of renowned jurist, Honorable Justice Srikrishna, retired Judge, Supreme Court of India, who is our keynote speaker and special guest of honor. And I'm also joined by esteemed and learned panel members from the fraternity. Uh, the flow of the program would be that I would give you certain examples and what is presently hotly debated in the news, uh, and then introduce Justice Sri Krishna to you uh, as a as my special guest for having consented, who's one of the masters in in this field also, because there is a drafting of the data protection law which has happened, and he was also the chairman of the committee of experts, and which will be then followed by a panel discussion. I am conscious of the fact that Justice Shri Krishna has also got another schedule which is coming up. He will be there as a keynote speaker with us for a short time, but I'm really privileged and honored for the time he has given to us. Just as an introduction to this subject, we are today living in the era of digitization where everyone thrives to be a tech savvy person. You have smartphones which have come up, you have data exchanges which are coming up, and simultaneously, when you speak to the lawyers fraternity or you evaluate judgments on privacy, fundamental right, privacy is now recognized as a fundamental right under Article 21 of the Constitution of India. But as we move towards the digital world, and it's a step towards more effective and organized sphere, we have moved from paper books to ebooks. We have moved from social gathering to virtual gathering. We have moved from conferences to Zoom meetings, as you see today. We are moving from banking to e-bank, markets to e-commerce, platforms and restaurants to Zomato, lockers to clouds. Everything is just a click away. But has it ever occurred to us that in the process of easing things for ourselves, we have made it more complicated by putting up personal and sensitive details online, and we have incidents of leakage of personal information, including credit card details, which the digital world is required, and wherein we thought that the regulation would have to address this violation of privacy. And for those who argue on the lines that we have enough data privacy law in place, we have laws, but we require a definite law with effective remedy considering the privacy right, which is recognized as a fundamental right by the Supreme Court of India, to an extent that in a recent order by Justice Pratibha Singh, Judge Delhi High Court, the court also recognized right to be forgotten and directed Google and India Kanu to remove or block judgment of an American citizen who was acquitted in NDPS case. Numerous examples of violation of data privacy has been there. I would just give you 9 examples and then I would proceed to Justice Sri Krishna. Marriott was a victim of another guest record breach in March 2020. The company announced that up to 5.2 million records were compromised. Unfortunately, this incident also happened in March 2018 or 19 in a Marriott hotel in New York. For unfortunately, I was staying in that hotel at that point of time, but fortunately, my data was not breached. When Zoom signups were nearing their pandemic peak in April 2020, hackers breached about 5 lakh accounts and either sold or freely published them on the dark web. I can assure you this meeting is now in the safe zone. 3 lakh Nintendo game accounts were compromised and used to make unsolicited digital purchases. Men's clothing store Bonobo suffered a data breach. The data of over 12.3 million was leaked. Data inclusive of 7 million shipping addresses records, 1.8 million account information records, and 3.5 partial credit card records. Pizza delivery service Domino's India was in the news recently, is the latest victim of the massive data breach that exposed about 18 crore pizza orders made via the service. Uh, WhatsApp, the social media messenger application, which has become wild for almost everyone across the globe, was recently in the news because of their new privacy policy. The government has sent WhatsApp a notice asking them to withdraw their new privacy policy. The government said changes and the manner of introducing them undermine the sacrosanct value of informational privacy, data security, and user choice of Indian users. We are also very aware that CCI has also initiated investigation into the same. Just a couple of that, even Air India was in the news. And last but not the least, just a day before yesterday, the European Data Protection Supervisor launched an investigation into the use of Amazon Web Services and Microsoft Azure cloud services by EU institutions. The European Data Protection Supervisor has also initiated a second probe onto the use of Microsoft Office 365 by the European Commission's antitrust watchdog. The probes are related to Shreyam 2 ruling by EU's highest court last summer, which said that the previous Privacy Shield personal data transfer law between US and EU was no longer lawful. And my last example would be a week ago, the social media messenger WhatsApp moved petition before the Delhi High Court, alleging that Government of India had brought new IT rules is a violation of privacy rights in India's constitution, since it requires social media companies to identify the first originator of information when authorities demand it. The question remains on whether such an approach and stand can also be taken in other jurisdictions like EU, US, or is it a particular jurisdictional issue or resistance, and whether the same may also be in conflict with a landmark judgment of Supreme Court in Justice KF Puttaswamy versus Union of India, which further ruled that privacy is a fundamental right, though it is not an absolute right. Technology is growing at a jet pace, but the question remains, how do we maintain the balance between the developing technology and the legal system when it comes to data privacy and protection? With this introduction, I now go to Justice Srikrishna. We have the august presence of our renowned jurist, Justice Honorable Justice Srikrishna, retired Judge, Supreme Court of India, who has blessed this program as a keynote speaker and special guest of honor. It's indeed a privilege and honor to introduce Justice Srikrishna. Justice Srikrishna is a globally renowned and celebrated jurist and a retired judge of the Supreme Court of India. In 1967, Justice Srikrishna entered private practice in Bombay High Court, and besides appearing in the High Court, he also argued in the Supreme Court of India and was designated as a senior advocate in 1987. Justice Srikrishna was appointed as an additional judge of the Bombay High Court in 1990 and a permanent judge in 1991. In 1993, Justice Srikrishna assumed charge of the Commission of Inquiry. In September 2001, Justice Srikrishna was appointed the Chief Justice of the Kerala High Court, and on 3rd October 2002, Justice Srikrishna was appointed as a judge of the Supreme Court of India. On 21st May 2006, as per rules, on reaching the age of superannuation of 65 years, Justice Srikrishna retired from the Supreme Court. Justice Srikrishna is currently an international arbitrator and is frequently engaged and consulted by well-known corporates, state governments, and Government of India on sensitive and critical legal issues, including internal probe into claims of conflict of interest, and at times, Justice Srikrishna is also called as SOS of the government on critical legal issues, which are watched globally by international communities. Justice Srikrishna has been an independent director of the National Stock Exchange and has also been a director at NSDL e-governance infrastructure. Post his retirement, Justice Srikrishna headed various committees formed by governments on critical and sensitive matters, such as Financial Sector Legislative Reform Commission, Sixth Pay Commission, Commission on the Bifurcation of Andhra Pradesh, Financial Planning Standard Board of India, Expert Committee on Arbitration in India, and the Committee of Experts on Personal Data Protection Law, which was formed to make specific suggestions on principles to be considered for data protection in India and suggest a draft data protection law. It is my honor and privilege to welcome the most distinguished jurist of our country, Justice B.N. Srikrishna, for the immense contribution to the legal field as jurist and towards drafting and contributing to the law on data protection, and blessing on us today as keynote speaker and special guest of honor on the program Data Privacy in Digital Era, Myth or Reality. Welcome once again, Justice Srikrishna. It's really an honor and privilege to have you. Sir, all yours. Thank you. You're on mute, sir.
Thank you, Zameer. I was wondering whether it's a webinar on Justice Srikrishna. It's not. Thank God for that. All right. Zameer, all the distinguished panelists, the stars in the legal firmament that I see in front of me, all other participants, my greetings to you. Data privacy has become a buzzword today. Every second day I am asked to talk about it. Every second day I read about it in the newspaper. And every second day people offer all kinds of comments on data, data privacy, lack of data privacy, etc. Now, let me just sort of encapsulate the issue that arise and then leave it for you to debate how you go about solving it. The first is, data is an inevitable consequence of human life. And that's why the Supreme Court has recognized it as a part of the right to life under Article 21 and treated it as a fundamental right, the privacy to data. Now, I have heard a lot of people, of course, this all started in the United States, somebody saying that, oh, data is the new oil, and everybody echoes it without understanding the jurisprudential basis of that. When you talk of oil, you talk of a physical asset. Now, if I say this is my property, I can hand it over to Aakanksha, I can lease it to Zameer, I can sell it to somebody, Ankoosh, Mehta, or I can just destroy it. But the problem arises because the expression my data has a genitive case. A genitive case in English denotes, amongst other things, ownership also. And everybody focuses on ownership. Now, apply your mind to this situation. May you say, this is my friend. Do I say I own him? If I say, this is my wife, do I say I own her? These are my children. Therefore, it only denotes, in this case, an intimate relationship. Now, that the intimate relationship is valuable in terms of money, I cannot dispute. I accept it straight away. Now, that is why, please note, wherever there is no physical asset, law has stepped in and created a physical asset. Now, today, do you have a company balance sheet saying, oh, data is my asset shown under the assets column of the balance sheet? No. But IPR does. Please note, IPR is also an intimate relationship. That is why it was called intellectual property right. My right to say that I have created this trademark or this copyright or this patent is my right because it has my intimate relationship. And because I value it, the law recognizes it as something that is inviolable as far as I'm concerned. And that is why this is treated as an asset in the balance sheet of every company. Today, data is not. Therefore, to say that it is my asset and all that is not understanding the jurisprudential aspect of it. Now, next we come to data is precious, but data is like, when a ship sails, you will notice there is always some leakage of water somewhere or the other is always dripping down. Or let's assume that you have a big bag full of coins, 10 rupee coins or even smaller change coins, and there is a small hole somewhere. So as you walk along the road, you'll keep on dropping these coins somewhere or the other. Sometimes knowingly, sometimes unknowingly, and somebody else picks it up. This is precisely what happens in data. Whatever transactions we take in life, there is always some amount of data thrown about, whether you go into the beauty parlor or whether you go into the cinema house or whether you go to the airlines for reservation or just enter the restaurant for a cup of coffee, your data is always accessed. And of course, the inevitable nuisance that we have with all the smartphones, which have turned us into idiots, the smart TVs, which have turned us into idiots, all this has happened. Now, when this happens, several questions arise. Now, I will come to this argument that, hey, our laws today are very fine, they can take care of this. I'll deal with it a little later. Now, data is constantly breached. When you say data is breached, what is it that is suggested? Now, data gets accumulated in every transaction in the hands of somebody. That somebody has no obligation to keep it intact for you. That somebody may use it, may throw it in the basket or make money out of your data. So today, is there a law which says how my data is to be treated in the hands of somebody to whom I have given it? When I give data to somebody, I give it is for a sense of purpose. I give it my data for this purpose of a particular accomplishment of a purpose. And if that person uses it for some other purpose or for benefit to herself or himself, that is breach of my confidence. That is why you require a law which says exactly what the contours are. Now, breach can mean several things. Breach may mean corruption of the data. This corruption of the data, I'm sure everybody who has had a ration card will know this. Every time you write neatly in English or in Marathi or in Hindi and give it to the officer concerned, but when the ration card comes to your hand, you will find that everything is confused. The fellow doesn't know how to write English, how to write Marathi, or how to write Hindi. And he will make a mess, and even sometimes you wonder whether it's your card at all. Only exception is the Aadhaar. Aadhaar people were very particular because that would have created infinite complication. But ration people were not. So that is it. Is the data corrupted in retention and transmission is one method of breach. The other is involuntary. The data gets corrupted on account of the mechanical failure of the receptacle in which you are keeping it, the device in which you are keeping it. Third is intentional hacking by somebody unauthorizedly accessing it. Now, what is the law which prevents all this? Which is the law which enjoins the person holding your data to hold it in an uncorrupted manner and to rectify it at my instance, on to hold it as a person of confidence for me and at my request, not to delete it when I want it. Is there a law in this country? I don't know. I thought I had studied some law sometime in my life, but I have not come across that law in this country as yet. Yes, there is some kind of a vague law, the rules under the IT Act. Now, I do not know if any of you can put your hand on your heart and say this is enough for us. Now, please remember, before the SEBI was established, there were a lot of financial transactions taking place in the country. There was Companies Act. There was also the Department of Companies Law Administration at the center level, which had regional directors in every state. Why did they have to have a separate act which deal with it and a separate regulator to dealing capital market transactions? Or take, for example, insurance. Insurance was for a long time being dealt with across from hand to hand like any other contract. Why did they have to have a regulator to deal with it? You have a big regulator called the Retd, which deals with insurance on a specific level at various levels of micro and macro levels. Therefore, it is not easy to say that, oh, one law will be sufficient to deal with everything. Now, Zameer, you refer to Shram's judgment. That is another aspect of the matter. So your breach can take place at the hands of a private data fiduciary or at the hands of the state. Now, before I go to this, what happens? I'm sorry, am I taking more time than necessary? Then I'm willing to cut short here.
No, you are absolutely on time.
Please signal.
Yes, sir.
This
Yes,
is a
sir.
subject on which I have talked so many times that I keep talking all the time.
Please go ahead, sir.
All right. I'll try to keep it as small.
Please go ahead, sir.
As short as possible. All right. Shram's judgment. Shram's judgment is a signal judgment which we must all remember in India. What happens is, Uttaswamy judgment declared privacy of data as a fundamental right. And like all fundamental rights, you have that famous article, sub-article 2 of Article 19, to which everything is subject. Under these circumstances, the state can take away the state can infringe your fundamental right. That is true of your privacy right also. But then, please note, sub-article 2 is very specific under what circumstances, for what purposes and all that. And therefore, the law which is made, another thing, fundamental principle of constitutional law is that you cannot infringe a fundamental right except by legislation passed by a competent legislature. It can never be accessed, it can never be infringed by an executive order. Some babu sitting in Delhi can't write a thing and say, from tomorrow I'm taking away your right. That is not permissible in this country, fortunately till today. Now, Shram's judgment is a very curious judgment, and I should say a very important judgment from our point of view of our country. What was this? Data Shield was an agreement between companies in Europe and companies in USA for transfer of data across the Atlantic Ocean. Now, in US, the federal law allows federal investigating agencies at the instance of the president to access all data held by any company on American soil without the consent of the person whose data is being held. Now, this is something that can never be stopped. The European court in Shram's case said, hey, look, this is absurd. In our country, we are very careful about keeping the data appropriately, and the GDPR is a very strict law. Now, in US, as soon as it goes to US, the president, somebody in the executive order will say and take it away without the consent of the person whose data it is. They said, sorry, we don't agree. That is why Data Shield was struck down. Now, turn the focus to India. In India, what has happened is, so far there is no law. In fact, that was the first question that Supreme Court asked in Puttaswamy case and said, where on earth is the law pertaining to data privacy? And that is why post-haste on a Friday evening, the government called me up and said, please, we are going to start a committee to go into this question. And that is how I was roped in. Now, data privacy law helps us in several ways. One is ensuring that data held by somebody is kept intact, not subject to corruption, not subject to breach, not subject to leakage to somebody else, and at my disposition. The day I want this data to be destroyed or deleted, I should be able to tell him and say, that is exactly what your right to be forgotten. You remember that famous judgment in the Delhi High Court. That is the right to be forgotten. Now, this is one right I want the right to be forgotten myself, but nobody seems to accept it. They keep on asking me to do. 15 years since I retired from the Supreme Court, and I'm not forgotten. That's a serious thing for bothering me. I also want to exercise my right to be forgotten one of these days. Anyway, that's aside. Now, the data can be accessed. The Supreme, please note, Puttaswamy judgment laid down 3 fundamental principles. They said the state has a right to access data with your consent because under certain circumstances, the state had to exercise this right so that the fundamental rights of all other citizens are protected. That is the reasoning why Supreme Court has given. But subject to 3, A, that there should be a parliamentary legislation for that. B, that the excess should, this legislation must declare the objective for which the data is to be accessed. And number 3, that the access of data without consent should not be disproportionate to the objective that is to be achieved. Now, first of all, there is no such law in this country. Much less is, actually there is no law on data on the subject of data privacy at all. Therefore, today, the big issue before the government is, should the right of access be given to the government freely, as the security agencies seem to be contending before the JPC, or should the rights be protected, but subject to some severe restrictions as in the case of other fundamental rights. Now take, for example, Article 21 applies to my right, freedom. Now, can anybody just arrest me like that and take me away? There is the Preventive Detention Act. If you want to do without a charge, then there is the Criminal Procedure Code. Every one of them protects me. Now, why does it protect me? Because it is enjoins upon the agency of the state not to infringe my fundamental right, except in accordance with the law. that is laid down by Parliament and the methodology prescribed by Parliament. Now, this is precisely what is required in the case of data privacy. Now, today what has happened is data privacy in apps has become a big issue, on social media has become a big issue. And naturally, the government wants to have some kind of a control over the social issue. And that is, of course, I don't want to talk about the legality of the WhatsApp case for the simple reason that it is still sub judice. And I don't want to be charged with contempt of court. You know, I have always been told that when a matter is sub judice in the court, your speaking on the subject will amount to contempt of court. So I do not go into the WhatsApp case. I only say that, yes, with regard to the social media, the question that arises is, what is the purpose of the social media? And I'm just raising these questions, you may debate it. Should the social media be as free as the press? What is the nature of the freedom that has been permitted to the press in this country, right from the Express newspapers case down till yesterday? Should this freedom be accorded and protected as far as social media platforms are concerned? And if so, are there no situations when the social media should be controlled as far as distribution of news is concerned? If so, what should be the methodology by which it should be applied? Because we are all talking of fundamental rights, fundamental rights. Data privacy is fundamental right. Like all other fundamental rights under Article 2, sub-Article 2 of Article 19, what are the methodologies under which Parliament can say, yes, I can do this? This is an issue that needs to be considered carefully, and I'm sure with the panel that you have, such galaxy of lawyers, you'll all be able to debate and come to some kind of a conclusion as to what the way forward should be. I think. Thank you very much for giving me an opportunity of sharing my thoughts with you.
Thank you.
For some time, I'll stay with you and listen to all the proceedings.
Right.
If you have no objection.
No, it's a privilege and honor, sir. Thank you so much, Justice Srikrishna. I think once again, sir, we are so highly obliged to you for your time. I think you gave us two perspectives. One is that the right of privacy is fundamental, and when you proceed under 19.2 on the freedom of expressions, I think one has to consider the angle of the reasonable restrictions when you were trying to compare it with the press freedom which is available in the country. And I think as a democratic setup, we have done to an extent. And I think both sides have to be balanced and addressed in accordance with that. Highly obliged to you, Justice Srikrishna. I think.
Let me make one last remark.
Yes, sir. Yes.
You see, you're right. The two rights have to be balanced. Now, the balancing cannot be done by one of the players. Please note, when the cricket team plays, who is the umpire? The umpire is the person who is not in this team, not on that team. That is where the necessity of having the whole thing being adjudicated by an independent judiciary. The Babu sitting in Delhi cannot say that I'm going to say, therefore it is right. No. This is precisely the point. So the balancing is always the job of the forum that is independent. The executive is not independent, nor is the citizen independent because he has his own voice to say in the matter. Nor is the company which comes through the court independent because it has its own game to play. Therefore, the balancing has to be done by the judiciary at some point of time. And hopefully they'll do it rightly.
Yes, Justice Srikrishna. And, I'm conscious of the fact that Honorable Justice Srikrishna has another commitment. And without much delay, sir, while you stay on this panel, I would like to once again, together with all my colleagues, Lex Witness and Society for Corporate Legal Experts, thank you from the bottom of my heart. And it was our privilege and honor that we were blessed to have by your august presence and wisdom. Thank you again, Justice Srikrishna.
Thank you.
And sir, you can be here till whatever time which permits you. I know you have a further commitment which is there. Right. And we now proceed to the panel discussions. So I have a colleague, Devyata from Narsi Monji. I have an elite panel with me for panel discussion. I will just take the name of my panel members for also introduction. Once again to Justice Srikrishna. I have Miss Aishwarya Bhati, Additional Solicitor General of India, Senior Advocate, Supreme Court of India. Mr. Ankoosh Mehta, partner Cyril Amarchand Mangaldas, Mr. Abhishek Malhotra, managing partner TMT Law Practice, Ms. Aakanksha Kaul, Advocate Supreme Court of India, and Mr. Kanu Agrawal, Advocate Supreme Court of India, also associated with the Solicitor General Office. Welcome to all my panel members. I request Devyata to please introduce all the panel members. Thank you.
Zameer, if you don't mind, I just wanted to say that Justice Srikrishna, I mean, I've known him since many years, and he's been an inspiration. Or I think one thing is there, he's been always there. I mean, if you need him or for anything, I mean, I know we've invited him to our firm for the smallest of things, for the smallest of guidance. He's just there. And, you know, so, sir, the right to be forgotten will not be available to you. So I'm just telling you that.
Okay, let me tell you the right of privacy to data. I told you data should not be corrupted. Zameer said I started practice in 67. He knocked off 5 years from my practice. I started in 62. That is why data should be protected.
Social media.
No, sir, I think Zameer was only trying to be, sir, mindful of the fact that you asked for the right to be forgotten. So we've forgotten for 5 years, sir. No more than that.
I want to be forgotten now, not.
No, sir, that's not happening.
I didn't want to be forgotten. I want to do.
I just want to express, Justice Srikrishna, that you spoke about that balancing. So I think your right to be forgotten is imbalanced because of our love and affection, and therefore our love and affection is overriding your right to be forgotten in this case.
Thank you.
Thank you. It's a really honor to have you. Devyata, please, you can go ahead and introduce the panel.
Good evening, Honorable Retired Justice B.N. Srikrishna ji, dear panelists, the audience and the organizing team. It's my pleasure to welcome everyone to our expert panel discussion of data privacy in digital era, myth or reality, a debate on data privacy laws, policies and their effectiveness in the times when world has taken a step towards digitalization. I take this opportunity to introduce everyone with the organizers, Society of Corporate Legal Experts and Lex Witness. Society of Corporate Legal Experts is an organization that aims to bring the fraternity members worldwide and the student of law and commercial disciplines to come together for sharing their thoughts on commercial law, policies and current trends in these laws. Lex Witness is India's first magazine on legal and corporate affairs. For over 10 years, since its inception in 2009 as a monthly magazine, Lex Witness has become India's most credible platform for the legal luminaries to opine, comment, and share their thoughts. I now introduce everyone with our esteemed moderator, Mr. Zameer Nathani. Mr. Zameer Nathani is an LLB, LLM, PLD from Harvard Business School, Executive MBA from Nasi Monjee Institute of Management Studies, US IP Laws from Stanford University, Intellectual Property Rights and Area Certifications from WIPO, Private Equity from London Business School, and Merger and Acquisition from Harvard Business School. Mr. Nathani was a law firm attorney for renowned and global corporates such as Eureka Forbes, LG Electronics, Kaul Consultant Softwares, Johnson & Johnson, other MNCs from US, UK, Asia Pacific, etc. He was Associate Vice President, Reliance Entertainment, Head Legal, Balaji Telefilms, Director Legal, Raymond Limited. He is presently Senior Vice President and General Counsel for UFO Movies India Limited, India's pioneering and disruptive technology developer for digital format of all movies and other contents for movie theaters and new OTT and OGC platforms. Mr. Nathani is a recipient of the prestigious Harvard Business School Alumni Challenge Award from Harvard Business School, Alumni Achievement Award from Nasi Monjee Institute of Management Studies, and in addition to other renowned awards in the past, he is also a recipient of General Counsel of the Year Award from Indian National Bar Association at the gracious hands of Justice Srikrishna, ex-judge, Supreme Court of India, and chairman of the Committee on Data Protection Laws. I now request the attendees to place all their questions in the question and answer box visible on your respective dashboards. You can upvote and comment on the question as well. We will try and conduct a live question and answer round towards the end of the session. You may use the raise hand icon if you're interested to ask your questions live. In the interest of time and more questions, we will prefer questions coming into the question and answer box. Please have a look at your chat box where the webinar help desk will be posting updates regularly. I now request Ms. Sharma to take it from here.
Thank you, Devyata. Thank you very much. It is my pleasure sharing screen with such stalwarts of the fraternity and Justice Srikrishna himself. It is my pleasure to introduce the panel with you. We have Ms. Aishwarya Bhati with us. Ms. Bhati is Additional Solicitor General of India and Senior Advocate, Supreme Court of India. She completed her LLB and LLM from JNV University, Jodhpur, and has been practicing for over 23 years now. She was an AOR, Advocate on Record, for over 13 years. She was designated as Senior Advocate by Supreme Court of India in June 2019. Ms. Bhati was elected twice as Secretary for prestigious Supreme Court Bar Association in December 2013 and re-elected in December 2014 with a record margin. She has been a panel lawyer of Supreme Court Legal Services Committee, Supreme Court Middle Age Income Group, Legal Aid Society. And
I think you can't introduce for more than 30 seconds. You have to move on. You can't embarrass the person beyond 30 seconds.
Okay.
She's following the lead that Zameer gave.
All right. Ms. Bhati is currently the Additional Solicitor General of India. Next, we have Mr. Ankoosh Mehta. Mr. Ankoosh Mehta is currently the partner at globally renowned law firm Cyril, Amarchand and Mangaldas. Is currently the partner in dispute resolution team of the law firm. We have Mr. Abhishek Malhotra with us. Mr. Malhotra is the founding partner of TMT Law Practices, having offices in Delhi, Mumbai, and Bangalore. We also have Mr. Aakanksha Kaul with us. Mr. Aakanksha Kaul is an advocate in Supreme Court of India and has been practicing for over a decade and a half before Supreme Court, Delhi High Court, and various other tribunals.
No, I'm yet to complete a decade.
We have Mr. Kanu Agrawal with us. He is an advocate before Supreme Court of India. He has completed his LLB from National Law University, Bhopal. He began his practice in 2014 as a law clerk, research assistant to Justice Sakare, and currently is associated with the Office of Solicitor General of India. I now leave it to Mr. Nathani to take it forward from here and continue the panel.
Okay. Welcome again to everyone. I think we had the privilege of hearing Justice Srikrishna. We have an elite panel now for discussion on various issues which are coming out of data privacy, which have been in the news for a long time. I go directly to my panel. My first question to Ms. Aishwarya Bhati, Additional Solicitor General of India, Senior Advocate, Supreme Court of India. There was one statement which was made when the CCI investigation on the new privacy policy of WhatsApp, which came up, was initiated. There was an argument which was put forth, and it's there in the public domain, was that such issues that overshadow data protection regime do not constitute a valid cause of action under the Competition Act. This was one of the arguments which was given. Do you think the arguments such as issues that overshadow data protection regime does not constitute a valid cause of action may be not an issue under the Competition Act when the CCI questioned the change of privacy policy by an app? Do you feel it indicates an acknowledgement of the fact that data protection requirements in India had too much freedom and it has now exchanged hands? We recall Facebook Cambridge Analytica issue, which also came up in the past year. And is it at a point of no return for these companies, except saying to the users of the service to either take it or leave it, and resistance with the regulation in letter and spirit towards use of the data without considering data privacy norms or protection as stringent as GDPR? Aishwarya, all yours.
Thank you, Zameer. So let me try and give you what my thoughts are on the interesting question that you put to me. First things first, I think I would have been extremely surprised if they, with their battery of legal doyens on their side, if they did not raise this issue that data protection regime does not constitute a valid cause under this. I mean, with the slew of litigations, antitrust cases that they are facing in jurisdictions across the world, if they would have given it up so easily that, okay, you can constitute and you can, this falls in this umbrella and you go ahead and, proceed. So obviously their whole defense would have been gone. But this is only a facade. In my humble view as a student of law, I think this is a facade that they are putting up, because the whole basis of the the entire, litigation that is happening against them on antitrust platforms is that they're manipulating their position as market leaders, as, big tech has this superior position, which is pretty much unchallenged. And that superior position allows them to entertain, to indulge into practices which are not competitive, which cannot be. There is no competition really. So it is antitrust. It's clearly falling into the anti-competition regime, and it has to be evaluated on that notion as well. Now, the second aspect that you raised was, I think what you asked was, yeah, so what choices do we really have? I mean, having moved from complete freedom that we understood, I mean, data is relatively a new thing. I mean, when I say this is something that we've only been grappling with now for about 2 decades. So before that, we also did not understand the importance of data. I mean, we saw things like you gave 9 examples in your opening remarks. You missed a very interesting example that I wanted to give, that example of this month itself, US had to come up with the emergency legislation because of a ransomware attack that had happened on a pipeline. And ransomware, I mean, the reports are also that they had to pay huge amounts in ransom for that data which had been confiscated, abducted, or kept by this, and an emergency legislation had to be brought in. So that was one way that there was a direct impact to the citizens in the biggest democracy of the world. At least that's what they claim. And we all know, I mean, we don't want to go into the cases specifically, but we know the statements of the founder of WhatsApp on what was the platform, what was the promise that was held out when WhatsApp wanted to have more and more consumer base. What was the promise that was held out when WhatsApp was purchased by Facebook? That statement, I mean, it was almost like holding out that, data privacy means everything to us and we are doing this, that. But the point is, they don't put their money where their mouth is. Look at how they have, I mean, today, big tech feels that they are so big that they can, take on sovereign nations. When Australia asked them to fall in line and make some payments to the news agencies, I'm not, naming companies, big tech, they said, we are going to stop, Google will stop its operations in Australia. And well, they're also slowly learning. So Australian Prime Minister also just retorted, he said, as a sovereign country, we don't respond to threats. And they've fallen in line. So, and the whole facade that we are in today, that, we can't go back. No, we have to go back. The time has changed. More and more of our life has become online. We've moved from real world to virtual world in a very seamless manner. And as more and more people move there, as more and more life happens here, as more and more disputes happen here, dispute redressal mechanism has to keep pace. And I think, right now we are seeing heightened activity on this front because our data protection law is at the cusp of, coming into play. So everyone is trying to have that lucky draw period, or this is this bumper offer period that is available to them, not realizing that, India as a nation not only has a very robust background and fundamentals of data, of fundamental rights, of rule of law, but also you can't turn your eye to a market that India has. They can't just shut shop and go. They are, of course, they're wrestling, they're testing waters. Nobody wants to give in so easily. But well, those are some of my thoughts, Zameer.
I think excellently, because if you remember, Justice Srikrishna also pointed out that, when we evaluated financial capital markets, they have a regulator. When we evaluated insurance, they have IRDA. I think those are directionally which is coming out as an input, is that we'll have to see somewhere down the line directionally, because, today, when you evaluate GDPR, or when you evaluate an example of Marriott, which happened, it's in the public domain, that when last time the data breach happened, Marriott went to the regulator and admitted, saying that, it was not something we missed out on security. It was just a gap in the system. and still they landed up paying 7 million as a fine. So somewhere down the line, when you come to that stringency on data protection and balancing it with the reasonable restrictions, somewhere down the line, we'll have to pull out a specific, objectively, a message to everyone. But talking on the criminalization, Ankush, I'll go to you now. Talking on the criminalization part of it, because data breach has now entered into a domain, where there is a criminal liability, etc., which has been looked upon. What is the present standard of criminalization of breach of data privacy? And is there a scope for wider criminalization of breach of personal and non-personal data? Your views on that, Ankush?
I think, thanks, Zameer. And, I won't repeat what, of course, Justice Srikrishna has opined, very clearly, and what Ms. Bhati has said. But I'll try and put this in 2 or 3 buckets. I'll answer this first by asking whether the laws are enough as a deterrent value for a data breach. That's point number 1. Which are the laws get activated? And 3, do they really attach to all kind of circumstances? We are talking about data breach today, especially in the lockdown world or the pandemic world, and it's become so important. But I feel that this was already in existence, especially when the Information Technology Act was enacted in, way back in the year 2000. And I feel that's the only law that is available right now for us, to sort of invoke. Where those provisions are not sufficient, you go back to the, tried and tested golden Indian Penal Code, etc., etc. But, of course, it has, I'll try and explain this also in some sort of case studies or, real life scenarios that I've come across, and try and explain where the Information Technology Act has actually landed up penalized and criminalized offenses, where it has been silent, and therefore we have had to resort to other legislations pretty much for a similar, overlapping issue. So while the Information Technology Act definitely criminalizes, has a civil penalty breach and a criminal, breach for offenses, and it enjoins upon people to what kind of data needs to be protected, etc., etc. I feel a lot of amendments or a lot of things that require to be kept up pace with today's times needs to happen. That's point number 1. Incidentally, I was on the same table for a session with a very senior police official of the cybercrime department in India, and he was saying that cybercrime in India, again, whether it's data privacy or not, there are again overlapping issues, is increasing at the rate of 200%. And it's increasing so fast that the laws are not there to catch up. Right. So whether you can invoke, again, to summarize, whether a provision of the Information Technology Act will be available to you, read with an Indian Penal Code, read with Indian Contract Act, because ultimately it's a duty on someone, an obligation someone, not to further disseminate, your data. But coming to those instances, and these are matters that we've advised or come across on, of course, on a no-name basis. In one instance, one of our clients, a server, was lying in a premises, and our clients wanted access to it. And the server had government data, a lot of important data. While we invoked the provisions of the Information Technology Act, the law on enforcement officials were not very comfortable with the provisions that were there and said that this is a civil issue, go fight it out in court. So that's point number 1, where it could have been an out and out data issue. The second, in an acquisition, our clients acquired an Indian, our foreign clients acquired an Indian company. And along with that, they have to collect all the emails, etc., because that's where the data was. We couldn't resort to the provisions of the Information Technology Act, but had to go to Companies Act, which was talking about return of company property, section 452. So while there are, again, it was unrelated to email, a lot of software, etc., but that's again data, right? It's not my data versus your, but it's a company's data which is owned by someone. Right. The third, the intermediary liability, right? Today, an intermediary is what? Somebody who holds data for someone, somebody who passes on data for someone, right? As simple as that. Many years ago, somebody will recall, I don't want to take names, but there was an unfortunate incident of something publicized on a social media platform, as a result of which that person, I think, had to meet with his death. He was killed. It was some socio-political, some issue a few years ago. It didn't stop there. My clients were summoned. Why? Because they are the hosts or they are the intermediaries. And they were asked the question by, top police level officials that, hey, listen, why did you not stop this data from coming onto the platform? And, the answer was that we don't land up filtering this data, it's about 1 million hits a second all over the world. How are we supposed to filter this data? So again, we went back to Information Technology Act, IPC, so on and so forth. So only point I'm trying to make here is that while there is the Personal Data Protection Bill, which is yet a bill, and there are so many other things, I still feel there will be still many uncharted territories, and which will require some sort of, when you relate back to it, then okay, this is the law that will fit, or this is the issue that fits. So those are my views on terms of what can be criminalized, what can be a deterrent, what can be not, and somewhere we'll have to still go back to the existing laws.
Wow, wonderful. So probably you feel that a specialized law should be able to govern and cover those aspects of it, and that's what is your view probably on that?
Of course, I mean that is one big thing, but that's my personal view.
Okay.
And of course, there are a lot of, there are still improvements sought to the Information Technology Act as well with these OTT guidelines and all that. Right. So let's see where that goes.
Right. Abhishek, just to come to you, when we spoke about the criminalization part of breach of personal data, a week ago, when the social media messenger petition had moved to the Delhi High Court, alleging that the government of India, that the new rules, IT rules, is a violation of privacy rights in India's constitution, since it requires social media companies to identify the first originator of information when authorities demand it. What are the concerns about the IT rules 2021 with respect to data privacy of the individuals, specifically from the point of view of the first originator of a message, number one? Number two, what is CCI's view on the WhatsApp policy? That's how the investigation has started. And does the policy in its current form give any indication on the abuse of dominance, in your opinion? Abhishek, all yours.
Sure. Thanks, Zameer. Just before I start answering the questions that you put to me, just one nuanced sort of addition to what Ankoosh had also mentioned with regard to the criminal laws and whether there is adequate enough, available level of protection and provisions that are available under the law to address the circumstances. The manner in which our legal system and jurisprudence is framed, we need to, of course, whenever there is a vacuum, go back to the extant laws, the IPC, the CRPC, and look as to whether or not there is a possibility of fitting in any of these issues within that particular four corners of those legislations. What I think is important and what the specialized legislations bring in is the spelling out of the rights and obligations that attach to either a particular format or a particular domain, or a new set of rights and liabilities get created. I think the rights and liabilities vis-a-vis data protection were to a certain extent addressed under the IT Act. And that's why you have provisions like 72 and 72A, 66E that already deal with the aspects of penalty in the case of breach of privacy. And they have been further, explained threadbare in terms of the constitutional basis, therefore, in the Pottaswamy judgment. So I agree with Ankoosh to the extent that perhaps because we have a kind of a mishmash of sector-specific guidelines or provisions that relate to different aspects of the commercial transactions or otherwise. However, we need an omnibus legislation such as what we are proposing in terms of the PDP bill, which will clarify the exact contours of what the rights will be that an individual can seek to enforce against a person who's handling their data or mishandling their data. So that's just the one aspect that I wanted to bring about upfront. With regard to the questions that you put to me, at the risk that I'm putting myself up at, Justice Srikrishna highlighted that when a matter is sub judice, then if we speak about it, then there is a possibility that we could be getting into the zone of contempt. But just trying to steer clear of that. What do the intermediary guidelines actually bring about? in terms of the privacy aspects purely. It is that tracing of the originator of the message, which is an additional set of guidelines that are applicable to a significant social media intermediary. So merely because you're an intermediary, you do not qualify, under that particular provision. Merely because you're a social media intermediary, you will still not qualify. You have to be a significant social media intermediary, which means that 5 million threshold has to be crossed, which will, any social media platform which is worth its salt would possibly have crossed that. Then more importantly, this particular aspect is applicable only to those significant social media intermediaries that are in the messaging domain. So it's a extremely small subset. And to my mind today, it's essentially WhatsApp, Signal, and Telegram to a certain extent, and whatever other entities sort of fall within that. Now, the issue here is that the whole, one of the, I think, attractive propositions, and I'm here talking more from a commercial standpoint of attracting more and more users, attractive proposition is the end-to-end encryption which these platforms are offering to their users. If that end-to-end encryption is not available, that is possible that it will impact them significantly from the point of view of the number of users that can continue to be on that platform. The whole point is that in the event that there is a requirement of law for which there has to be a determination of where the message has originated from, who is the person who is really responsible for the alleged offense or otherwise the reason for which the information is sought, it's very difficult to pin the liability, and it becomes a bit of an issue with regard to who do you identify as the person who's actually committed the alleged offense or whatever activity is complained of. So I don't think that there is an issue with regard to the aspect of whether or not the rule of law can actually seek an entity to have a system in place whereby not generically, not without the force of law, but on a specific order passed by the appointed authority, that particular information has to be made available. I think where the challenge, to my mind, which is being brought up is, can that be done by a delegated legislation? And the question also then comes about is whether the IT Act with its existing provisions is enough to cater to that situation, which in my personal view, it is. There is a whole slew of provisions, 66, 66E, 67, 69A, 69B. There are a multitude of those provisions that already grant that power to the government and to the relevant authority where it is so required to seek that particular detail or that information. So really speaking, the focus of these regulations that were notified was originally supposed to be, and that's the rule-making power under 87.2 ZG, which has been invoked. And if you read that with 79 says you are an intermediary, you get a safe harbor. When do you get a safe harbor? When you comply with X, Y, and Z. One of those X, Y, and Z is the guidelines that are notified by the government. Now, the guidelines, as they were available in 2011, from the guidelines which have now come about in 2021, there is a substantial amount of difference in the focus and implementation. Is this what the intent of the guidelines was as set out in 79.3? I don't know. That's perhaps what the courts will go into and make a decision on. But to my mind, the existing provisions were adequate enough to have addressed this issue. The last part of the question that you'd asked me with regard to the CCI case, it's a very interesting matter, Zameer, because there are two parts to the answer. The first part is, can the CCI get into this question at all at the aspect of jurisdiction, which is also being debated, and Ms. Bhati also gave her views with regard to whether or not the CCI can really get into it, and from a jurisprudential aspect. The judgments that the CCI has actually given in the past, whether it be in relation to the telecom sector or the broadcasting sector or otherwise, The CCI has said, look, I am not going into a broadcasting issue. I am not going into a telecom issue. I am going into a competition issue, which impinges, which could or could not be a pure competition issue, or it could impinge allegedly upon the jurisdiction of a sector regulator. So when there was a telecom issue with, with when Jio and Vodafone and everyone was in court with regard to the Jio's plans, the issue was TRA is powerful enough and they have enough regulations to be able to address it. Why are you the CCI getting into it? Went up all the way to the Supreme Court, and Supreme Court said, look, to the extent that the sectoral regulator has the jurisdiction and power to exercise it, the sectoral legislature can decide what to do. But if there is a question of competition law, the CCI can definitely get into it. So I think here, the interesting issue is there is no sector regulator currently in the data protection sphere, right? So the answer becomes a little easier to be given that perhaps the CCI can get into it. The more important and purely competition law aspect, which will be interesting, is you are looking at an investigation into abuse of dominance. When you're getting into that question, and when you're saying that this is a dominant player and it is some sort of a monopoly, the economic principle to be applied is a supply side from the point of view of what is being supplied. Whereas in the present situation of the WhatsApp case, it is more a network effects portion where it is determined by what the demand is. The consumers are demanding the ubiquity and the stickiness of the platform gets better when more and more consumers are coming to that particular platform. So the consumers are driving that. The consumer demand is driving the value and the valuation of that particular platform. To balance out these economic principles and to come out with a decision, I am quite excited to see what the CCI gets into. And of course, there has to be evidence generated and to see factually whether this is made out. But I think it's very interesting to be looking forward to.
I think that's a good distinction on the absence of a regulator on the data protection, and also a clarification on the competition issue by Supreme Court of India, where CCI can intervene, and it's an interesting case to also watch when the matter is presently under investigation on the new privacy policy of WhatsApp. And let's see what happens. Yeah, I look forward for it. Aakanksha, going to you, we spoke about data privacy, we spoke about constitutional rights, we spoke about reasonable restrictions, we spoke about the messaging domain. I now come to the social media and the OTT domain with you. And my question to you is that social media and OTT have now become the new magazines and cable TVs of the world, where people prefer easy access of content. More usage of which includes more data sharing. The question that arises is that how safe is the data of subscriber? Just to give one example to our audience, there's a book on experimentation by a Harvard Business School professor who launched it in Mumbai. He says, while you're on booking.com website and you're booking your holiday, there are 10,000 experiments which are happening behind your back on that particular platform. What color did you like? So those kinds of things are determined by way of those experimentations. So the reflection is that more data sharing happens because of the more usage you do. So your preferential part, etc. Recently, the news of biggest data theft, data and login credentials of the subscribers of Netflix, Gmail, LinkedIn went viral. Taking into consideration the same and the recent regulations, what are the parameters of data protection regulations that have been incorporated in the new legislation? And if not, then how is the legislature willing to address the aforementioned issues? Aakanksha, all yours.
Good evening to everyone. I don't think, starting with the last part of your question first, the current regulations itself, the rules don't really deal with, in my opinion, data protection, at least from the consumer point of view. The data protection bill is a different issue. I think that deals with a lot of aspects. So we'll have to really wait for that to come into force for any sort of real protection for the data of general consumers to be given any sort, for them to have any sort of protection. I think the first most important thing we need to appreciate is that we today are talking about data protection because we have an understanding of how our data is getting collected and stored. But a huge part, if not majority of the population in India is today using social media platforms, be it TikTok or Instagram or various other platforms, even something like Google or Google Maps, and is not conscious of the fact that they are actually providing data. They think that these are all free platforms. Well, you're not paying in the form of money to be able to use those platforms, but they're not really free because they are taking from you something which is your movement, your history, your data, and that's where they are getting money from. So I think it's really important to create consumer awareness and consciousness. I understand that there's not much we can do at present because when you sign in to use any of these platforms, there's not much freedom given or choice given to consumers. On paper, maybe to some extent, but practically speaking, not really. But I'm hoping gradually as the laws develop in India, we will be given a choice. I also feel once the bill actually comes into effect, the data protection bill, the idea of disclosure and the obligation on these platforms to disclose what kind of information they're collecting, for how long they'll be storing that information, for what purpose it is being collected and stored. That information, that obligation to disclose will be heavier because at present, we don't know. We don't know what information they're storing. I mean, we can speculate, partly because of the target advertising. You suddenly see all these adverts popping up, and you realize that obviously there is some website you visited because of which a particular advert is coming. So at present, we only gather from various other circumstances around us that there is data being collected, but we really don't know what is being collected, what is it being put to, for what purpose. So that, and I feel we also need some sort of compulsion on these social media platforms, all OTTs, etc., to give us a choice which is a substantive choice. To choose what data is it that we are willing to give to them. In what capacity can it be identified? Can we be identified through that data? Those are some of the laws which are better regulated, I feel, in some of the Western countries, more developed. In India, they are at a very, very nascent stage, but we need them because we have a huge population that is increasingly shifting to and using social media platforms, OTTs. I mean, people hardly today watch TV as such. It's more on OTT platforms. So that obligation needs to be there.
Right. I think the interpretation of government also came from the two perspectives that, whether the user is in the position to, be a decision maker in the process. Second thing, I think what also was very much highlighted when this issue came up for a messaging app is that they said that, the policy is either take it or leave it. That was one thing got highlighted. The third aspect is that whether these norms will now require a law and a regulator in place so that, the exploitation, because what happened really during these times also, if you see two sides of the coin in Facebook and Cambridge Analytica issue, where the information was being shared, Facebook said it's covered under the terms and conditions, so that was the first part of it. The second part of it was whether the user was aware that, this kind of data exchanges do happen, and Facebook Cambridge Analytica issue highlighted much of those things from where the debate started, that, whether this data is only restricted to certain informational usage, or is it commercially also exploited, and therefore your free service is basically a boon to the companies, what you highlighted?
Just on the issue of, I think at least this regulation deals with making people, highlighting the privacy policies. So to that extent, it will help, so that I don't know how prominently it'll be highlighted, the policies and what they are doing. But the second part of it, as to what they're collecting and giving a substantive choice, that will only come into play once the data protection bill becomes a legislation.
Absolutely. I think that is what was being also expressed in the forum. Kanu, going to you, data privacy issues have now proliferated in the increased use of social media over the past years. The number of data theft cases has also alarmed the users about it. With this, the most commonly messaging app, which is being used across the globe, has come up with a new privacy policy, which became a controversy. It gave two options, either to agree with it or quit the app. In other words, the new policy making it a mandatory compliance for the user. CCI took a suo moto cognizance of the case, has rendered the policy to be an abuse of dominant policy under Section 4. Investigation is on, its matter is sub judice. What's your take on the privacy policy assessment at a legal level, a legal assessment of the same, without getting into the domain on the other side of it? Kanu, all yours.
Thank you, Zameer ji. I think as the youngest member of the panel, I'll just take forward what my learned senior, Madam Bhati and Abhishek ji, Ankoosh ji, and obviously Aakanksha have said. So I'll come to the policy a little later. I think one of the points that Aakanksha raised is an extremely important point, is the point on consent. Even in Indian contract law or other say even criminal laws, an uninformed consent is considered to be vitiated consent. In contract law, you cannot enforce a standard form of contract. Today, what these companies and all social media companies, whether it's Twitter, whether it's Facebook, whether it's Google to a great extent, whether it's Google Pay, whether it is Paytm or any other company, they give you a standard form contract, which, by the way, is not even a printed standard form of contract, which, the classic British case about the ironing guy burning your t-shirt would have given you. They give you it in a form of a click wrap contract.
Yeah.
There's a delicious irony there. When these same companies want to explain their product, they explain it. Today, Google is virtually functioning in each and every local Indian language. When Google wants to explain its product, its maps through which it acquires data of the citizens of this country, it completely adapts itself. It will give it to you in a voice format. Today, 2-year-olds are able to use YouTube because they can click on the button in the TV and they can give a voice command. So anything that enables these companies to collect more and more data, they adapt it according to the user. But till date, I do not find any company who is trying to explain the terms and conditions in the same interactive, user-friendly manner that they want to explain their products with. I think this is where the role of governments, or in fact, considering the nature of the beast, I think we are perhaps a decade or 2 decades late in terms of regulating it, because they have become imperium in imperio. They have become, according to me, too big to be regulated. So there has to be a global movement. The pending bill is a start, but I think considering the nature of the beast, and as Justice Srikrishna has said, is very important point, that ultimately what is data? Data is intangible. If it is intangible, it becomes even more difficult to regulate. So I think consent is an issue that Aakanksha raised, which was very important. Coming on to the WhatsApp policy, see, we need to first understand where we are. Even the current WhatsApp policy leaves a lot to be desired. So let us not kid ourselves that like as if the current policy is something that we would, as privacy enthusiasts, would want to continue with. Even the current policy is problematic. The new policy obviously is maybe deeply problematic, but in some aspects, I do believe it might be better than what the current policy is. Now, when often we discuss these technological issues, a lot of people often get lost in the jargon. And despite being the youngest member, I'm also not really a tech savvy person. So I generally try to simplify these issues. When we discuss the issue of whether the Competition Commission has jurisdiction or not, the Bharti Airtel case of the Star India case, I think very rightly has been distinguished by the commission in its order in the suo motu case for the simple reason that there is no regulator, there is no TRAI when it comes to entity like WhatsApp. For me, WhatsApp is a private corporation. The private corporation is offering you a service. The service in terms of purely monetary value is a free service, so to say. The consideration actually, again, if we don't kid ourselves, is our data. So that is the transaction. That transaction happens on the basis of the terms and conditions that they provide, a part of which is the new privacy policy. So as a private player, they are fully entitled to, I am a strong believer in free markets, so they are fully entitled to say that take it or leave it. However, as soon as you understand it as a private contract between a seller and a buyer, with us being the buyers and them being the sellers, the role of the commission straight away comes into play. Classic principles across the board of abuse of dominant position would be applied. If data itself is a commodity, if data is the consideration, the CCI would be empowered to regulate it. Yes, obviously, ingenious lawyers should question it. Ultimately, good law is only framed when there is a strong challenge to it. So even worldwide, Japan today, to my understanding, has come out with a legislation which says that antitrust actions will be taken against these companies. Germany has already imposed a penalty. The US relevant authority, according to me, has filed a lawsuit after doing an assessment. So we really need to lay down a determinative factor, which is where the data protection law comes into being. That law, as Justice Srikrishna said, will lay down the parameters on which we can protect our data and the parameters on which that data as an entity can maybe used by these companies. I believe we have really fallen behind, and as I said, the law, data protection law will be a first step, but I think I don't think that it will lead us to a final solution. A final solution, or in fact, a real impetus would be gained by a global movement. There has to be a global movement to it, considering the nature of the beast. If we deal with today international taxation or the problem of tax havens, we consistently fail on it for the simple reason that there is no global movement around it. In a similar fashion is the problem of privacy. There is no data localization there. You can bring in a legislation. I mean, even the Justice Srikrishna reports devotes pages after pages on enforcement or what is happening with, I don't want to comment on it, but what is happening with a social media player right now between Government of India and that social media player.
Right.
Enforcement is a real issue. We say that we'll adopt a soft touch approach of what they've done in the OTT regulations or what they've tried to do even with the proposed bill. I doubt that that's the answer.
Right. I think I agree with you. So you are saying that, you know, the balancing which Justice Srikrishna was talking about data privacy, you're going on a different balancing portion where you say data privacy and commercial utilization can be bridged together when there's a legislation which can balance both sides. I think you are propagating that point, and I think very rightly put that if you have a legislation in place, it also clarifies the parameters for data privacy, which protects the interest. And of course, as you hear Aishwarya in every forum, she says that there is a government who has to exercise the right of protection because as an individual, you will not be able to get into it. So that's where the parameters of the data protection and data privacy will be chipped in. And what is the extent of commercial utilization which can be permitted? That balance will come because of that legislation in place. I think you're propagating that idea, and I think very well put. Aishwarya, going to you. When we speak about this balancing, and if you all remember on August 24, 2017, Supreme Court of India held that the right of privacy is a fundamental right guaranteed by Part 3 of the Constitution of India. This decision will, of course, have a far-reaching ramification on the laws and regulations. Recognition and enforcement of claims qua non-state actors may require legislative intervention by the state. This was the remark of Honorable Mr. Justice D.Y. Chandrachud in K.S. Puttaswamy versus Union of India matter. Is this not enough to consider that Supreme Court of India, in its wisdom, has laid down the principle of law or principle of interpretation of law, and it is now a doctrine of stare decisis, meaning that a doctrine that obligates the court to look to precedent when making their decision and is also a guiding principle for the government to consider the same for legislation of law, which the government also did on content regulations similarly. Your point of view.
Yes, so well, before I answer that, Zameer ji, I must share my enthusiasm at being at this such a robust and dynamic forum. I'm always inspired by my young colleagues here, Kanu ji and Aakanksha ji. They're both rock stars in my opinion. Of course, I've worked with them a lot more, so I've seen how enthused they are about issues. I had a little less interaction in the court corridors with Abhishek ji and Ankoosh ji, but it's amazing the galaxy that you have here of experiences across the across the generations. The perspective is very interestingly coming forward. So, this Puttaswamy judgment, the privacy judgment, of course, it is the bedrock. It is the it is the fundamental basis. In fact, the whole data protection regime is being brought out on this itself, because the Supreme Court in its judgment said, highlighted this aspect that it needs to be brought in. And the Supreme Court judgment of privacy, it was a unanimous judgment, and it was a recognition of the right to privacy in the existing Part 3 rights. So it has, and obviously that is it is a finding by a very large bench, and there is no it has to be, it is the rule of law, and I don't see it being controversial in any way that it's going to go in any other direction. So of course that's how it is going to be. That's how the rollout has to be. One thing that I also wanted to comment on, Zameer ji, is you mentioned, you quoted me by saying that the government has to take the job of data protection and privacy. Well, because we are in a democracy, they are our representatives. We have put them in power. We have elected them to power. We question them by way of elections on a regular basis, on a periodic basis. And it is their job to run governance on behalf of the citizens, on behalf of us. So that is how it has to go on. And it's strange that an interesting argument has come up that whether Twitter or Facebook or WhatsApp protects your data or government protects your data. I mean, it's hilarious. It's ironical and it's hilarious at the same time to see that. Of course, ingenious, again, great legal minds at work. So ingenious, they know that this is a sort of sticking point in India, where it's very fashionable to be anti-government, to be anti-establishment. While it is important in a democracy, it is important for citizens to be discerning and conscious. But at the same time, discerning and conscious does not mean that you place confidence in the hands of a commercial entity that I mean, in any case, Part 3 rights are only, and WhatsApp is saying that also, Part 3 rights is for the government to do. I mean, why should we be? Part 3 rights is not available against us. Yes, but Part 3 rights, government is duty bound under the constitutional framework to make sure that Part 3 rights are not violated by anybody else. So if I am violating Akanksha's, any Part 3 right in any manner, I'm not government. But there it is, the loop goes on, because these rights, Part 3 rights, are also, you can't give a concession on. You can't voluntarily give them up. The Part 3 rights in India, fundamental rights, are put at a very high pedestal. And that is the whole length and breadth of the privacy judgment, to place privacy as a Part 3 right, recognize at that higher pedestal. And Justice Srikrishna already pointed out in the beginning that yes, these rights are not absolute in the form that they can be circumscribed by the conditions that are laid down in the Constitution itself, but only by a provision of law. It is not that they can be curtailed or restricted in any manner without a authority of law. There has to be a law that has to be framed to restrict those rights. And the onus is on government, on the elected government, to ensure that these rights are not violated even by these purely commercial entities also. They may think that they become too big. I will differ with Kanuji here a little. I mean, yes, we are a little late on the data protection regime to be there. But I don't think they've become too big to be brought into the rule of law. They are making a huge case. They are obviously they are struggling as much as they can to wriggle out as long as they can. I mean, they know eventually it is going to catch up with them. They can't really wriggle out for too long, and they want to make hay while the sun shines. So it is almost like all these issues have come up. I strongly feel that all these issues have come up because the nation is in a severe wave of the second pandemic. So the entire focus or a majority of the focus is there of governmental agencies. And B, it's a disaster. It's a national disaster that we are dealing with. We understand how things are everywhere. And B, this, the data protection regime being on the cusp. And this is, of course, we will see how it comes out in, ultimately as an act. But the bill does have very robust mechanisms in place. The whole onus is on the data fiduciary. The requirement of right to forget is, ingrained there. You have to, you have the consent, the manner, Kanuji and Akanksha ji spoke about consent. It is very specifically, laid out as to in what manner the consent can be taken. It has to be specific to the cause that you are taking consent for. It has to be time period specific. It cannot be for unlimited time, for infinite, reasons, etc. So that regime is in the offing. It is in alignment with, in my opinion, in alignment with the Singapore law and the Europe law, which are the best practices today that we see. So I think we just need to call their boogie, wait this out a little. I mean, the beauty of our country is that everyone has a fair chance in a court of law, and they have the right to raise all these arguments and all these ingenious contentions also. Our constitution permits that, so we will have a little amusement for some time till it all boils over and cools down.
Right. I specifically observe your word. It's a matter of time. So maybe probably time is essence. And let's look forward on that. But I think, yeah, it's about that. See, it's the whole intention of the Supreme Court when it recognizes as a fundamental right is also, the enshrinement is from the perspective of the protection of those rights. So the protection of rights has to be taken at some point of time. And there has to be a balance between the two. I think great views expressed by you, Aishwarya. Ankoosh, when Aishwarya spoke about this is something so critical that it's when I talk about data privacy, it also involves my financial data. When I speak about financial data of someone and the audience which is there in front of us, when somebody says that your financial data can be exposed, this is the grievousness which you feel that, this is the kind of disaster which can happen. Today, we speak about some data, we say, all right, it's available, okay. But your personal data, your private data, Aadhaar card, your bank account numbers, your financial data, if they are all exposed and available in the market, that's where the seriousness comes. Ankoosh, in your view, what is the course of action and or remedy which is available to a bank or a customer whose financial data has been breached? Ankoosh, your views on that.
No, I think thanks, Zameer. I just wanted to make one point. I mean, I think just overall, I think Justice Srikrishna set the tone, and literally we are getting such wonderful charged up views that it's, I think, one session won't do justice, to this kind of a topic. But anyway, moving on, I just want to make a couple of points. I'm just conscious on the time. One is that the Reserve Bank of India, of course, regulates, the protection of financial data, and also there are some cybersecurity existing, policies as well. But I think I'll try and explain this again, by way of a little bit of a practical, live experience that we are currently doing in two parts. One, very often we get questions from our clients who are banks and financial institutions or any other, companies which have sensitive data. It could be insurance companies, it could be, several other companies that have medical data. I mean, personal data is one thing, financial data, medical data, etc. And what they ask is that, in a rush of time, one relationship manager, one sales manager, one business manager conveyed that data over a I'm not naming it, but over a platform, over a messaging platform to the customer. Now, and that data got hacked, right? Now, it could be somebody's bank account, it could be somebody's medical, it could be whatever it is. And we're not getting into the type of data here. And the question is asked to me, what are we supposed to do? So I said, you need to go back to the basics and see your own KYC guidelines and whatever else it is to know that, listen, were you even permitted to share it? Maybe the customer asked you, it's okay, but now that action is done. Tomorrow the customer shouldn't escalate the issue saying, I asked something so simple and you didn't give it to me. So the comeback there is always that, look, you put this back on the official lines and say that, look, you had asked for this, data for me. I share it with you in interest of time. But, I sort of try and mitigate that or damage control that by way of sending it through the official channel. So that's your first preventive thing that you should be doing, especially when you're in a, dealing with a financial issue, medical issue, or anything that is really critical to the other person or to your own business at hand. So that's the first thing. The second thing is on when a damage has already happened. Right now we see so many things where, somebody's account has got hacked, somebody's monies has got siphoned off, so on and so forth. There is an enjoined duty on any in this case a bank, right, who maintains servers, who maintains software, who maintains hardware, etc., to ensure that that is protected. There are security protocols, etc., in place. If there is a breach, right, the first finger is going to be pointed at the bank, right? It's not going to be for the customer, because ultimately the customer is the aggrieved person. So the bank has to justify saying, okay, there's an internal investigation that happened and, we've come out clean. And this was some sort of a phishingware attack, a malware attack, whatever the case is. And as simple as something to speak, which we were doing, which we've advised on cases, where you get an email, from supposedly the bank, which has not come from the bank's account. And it comes at a midnight of a particular day and you somehow land up accessing it. You've submitted your data, right? And then the account gets, the money start getting moved around. And finally, by the time you realize, it's too late. So coming to the forum where this can go, originally, it can go to three places, really. One is a simple criminal complaint or an FIR that can be filed that your money is gone. Just cautioning you there that equally the bank is the victim. It's not like the bank is the perpetrator at the same place. The second, of course, the bank is going to be hauled up if it's not maintained its system in place. The second is a consumer forum, because there was a deficiency in breach of service. And the third, which is quite applicable, quite robust, in the Information Technology Act, where there is an appropriate authority concept that deals with these kind of issues. It has powers of a civil court, can criminalize, so on and so forth. So, that way mechanisms are available. One has to be, of course, in today's time where I was saying business is completely happened online, one has to, take more this. Digressing slightly on a lighter note, I think when Kanu mentioned, that, things were over so many decades. I'm not sure how many of, probably, maybe, Abhishek or maybe Zameer, or, when we were way back in college, there would be these organizations which would do this, which would take money or take, money from any company that was launching a product and actually go door to door and take data, and that way they would, then say that, okay, they would give this report to, the company was launching the data saying, this is what your market is looking like. At that point of time, just a comment, nobody thought about all this. Today it's all like, it's this thing was getting, of course, I'm not saying one way or the other, but I'm just saying that this was happening, from time that, we all probably can recall. So yeah, those were my parting thoughts.
You highlighted an important portion that, while this banking data violation happens, sometimes it's not all the time that, the bank is at fault. Even the bank is a victim of it. And therefore the technology and security, that part comes into picture. But, Abhishek, before I go to you, I just want to tell my panelists, we have some 25 questions which has come in. There are some questions on my WhatsApp and all that. So probably this session has been very much liked. I've been getting compliments on my WhatsApp, so I want to just convey to everyone. Justice Srikrishna was there and this panel is there. I'm getting a lot of compliments for the views which are there. We have so much questions, we'll be able to answer 4 to 5 questions, or otherwise we'll have to continue till the dinner, which probably is not great in the Zoom scenario. Going to Abhishek. Abhishek, we don't have a law on data protection as on date. In absence of any law, How are the breaches being dealt with today? And what will change, or how will this change with the personal data protection bill, which becomes a law in future? Abhishek.
Okay, so I think part of that question has already been answered by Ankoosh, but I'll just add some bits to it. So essentially, the deterrent factor in the present circumstance is already set out in the Information Technology Act and the IT Reasonable Security Practices and Procedures and Sensitive Personal Data Rules of 2011. The important aspect is as let's say an entity which is hosting or processing or controlling the data, I need to have reasonable security practices in place which are consistent with whatever is the prevailing standard. So currently it is ISO 27001. And if there is a comparative standard or something better which comes into being, the onus is upon me to demonstrate that despite that due diligence, despite putting in those reasonable security practices and procedures in place, this breach has occurred. So that the fact that, and the penalty for that, for not adhering to that, is set out in 43A, which provides for an actual financial penalty to be foisted upon the entity. So that, to my mind, is the possible way in which at least the people who are handling the data or controlling the data could possibly be made liable in the event of such a breach. But the important part to be looked at, and very often a lot of people forget this, is that the entity, let's say, the Air India breach or anything else, of course, the data of the people who were members, who had traveled, etc., their data has been put at risk with such a breach. But even the organization who was controlling or handling that data has also suffered that attack. So it is also a victim in that sense, right? And how do you resolve, or what are the provisions for addressing the liability towards people who are the attackers, the cyber attackers? That's under section 43. So there are provisions that already exist in the Information Technology Act with the rules. However, when we do get the PDP bill in its current form, and of course we could have modifications made to that in times to come, but at this juncture, the impact of the penalty is much higher. Right now, it could be about 5 lakh rupees, and we do not know, because the lack of information in the public domain as to whether the maximum penalty was actually imposed upon in such circumstances or not, is something we're not conversant with. But once the PDP bill in its current form becomes act, then the imposition of fine is to the tune of 5 crores or 2% of the annual global turnover, whichever is higher. And in the event that the breaches are more severe, concerning children or concerning some system that has not been placed. Importantly, in the first part where I said 5 crores and 2%, even if you've not conducted a data impact assessment, that amounts to not following the due diligence process to demonstrate that you have reasonable security practices in place or not, right? So it's going to be extremely important for entities handling the data to be not only having that basic infrastructure in place, but also to continuously either upgrade it or have those systems being tested from time to time to demonstrate as to whether or not there is preparedness. So once we come to that, then there will be a greater amount of penalty perhaps that could be imposed, and also criminal liability that could attach that. So I think current set of laws, when they were formulated, may have been considered adequate enough for the kind of anticipated attacks or whatever was not happening. But already we are already seeing that the level of cyber attacks has increased manifold. And you yourself, I think you mentioned, or perhaps Ankoosh mentioned, that 200% increase in the cyber crime. So not only does the infrastructure have to be robust enough to be able to handle that, but we need to have the law to provide the teeth to the enforcers to be able to achieve what they want to achieve.
Right. So I think the distinction which you're saying between the new act which will come in are 3. Number 1, it will add more to the compliance. Number 2, it will add more to the accountability. And number 3, in terms of penalties or fine, it's going to raise the bar. And I think that's the difference which will be there between
Correct.
the present situation and when we have the data protection law in place. Okay. While we talk about the seriousness of this issue at length, Aakanksha, US elections last time when Donald Trump got appointed for the first time, the allegation was that there are certain amounts of emails which were sent based on, so we are talking about data privacy and data protection. The data which was available, some amount of emails were sent in context of Hillary Clinton, and there was an allegation that which led to the appointment of Donald Trump as the president of the United States. If that be the critical part of the data protection and the data privacy we are talking about, there have been plethora of data theft cases among social media users. One of the issues faced by the regulator has centered around the role of bad players influencing the voice of social media tribes for the benefit of a few. A classic example of the same being Facebook data theft of 2016, wherein the Russian Operation Internet Research Agency was accused of interfering in the US presidential election of 2016 by social media to spread disinformation that stirred up conflict and distrust. In your opinion, is the current data privacy regulation tooth enough to govern such issues? If so, how? And if not, what are the measures that can be taken to avoid such circumstances, in your opinion? Data is politically being used now, and it has a lot of implications and ramifications. Your view on that, Aakansha?
So I'm not opposed to data collection. I feel that sometimes it can be of benefit. I mean, whether it is articles popping up which would be of your interest, of course, that is purely because your data is somewhere being collected. So there is a positive side to it. The negative side is that somewhere our opinions tend to get biased because our data is collected and then we only tend to get articles, reports, information that would already be aligned towards our way of thinking. So somewhere by not receiving adequate information, reports, which go contrary to our general opinion or the leaning which we have, and receiving more information only favoring our standpoint, we don't get the other view. And that's why I feel that a lot of people we don't have a very balanced opinion of subjects or events. It's a very one-sided opinion, and maybe somewhere that's also causing a lot of extreme opinions on every side of the political radar. The current regulations, the rules and regulations which have come, of course, a major part of it, I feel, is to deal with fake news, disinformation, which is a good thing. My only fear, actually, I feel that it does deal adequately with that aspect. My fear is actually, in fact, that somewhere in the process of trying to control that fake news, have we gone too far to a point where even accurate news will get shut down? So my apprehension is more on those lines rather than on, I think the current rules deal, we don't need more. I mean, a lot depends on how they get implemented, of course, and how they get interpreted with time. But I'm not so, I think that the protection under them is adequate to prevent fake news and disinformation, which is a problem. We can't deny that, and that does need to be controlled because every person today has access, can be a journalist for all practical purposes. There was a certain level of responsibility associated with journalists. You don't need that anymore. Everyone has a camera, everyone has a keyboard, and everyone has access to the entire world out there. So this was a problem that needed to be dealt with, but I don't know how we'll be drawing a balance between preventing fake news and actually preventing genuine news from coming out.
Yeah, in fact, what has happened is that, see, while the debate of data protection and data privacy is on, it's the use of the data, like Facebook Cambridge Analytica opened up Pandora box because there was a relationship between the parties, and users were not aware about it because users thought we give you information in good faith, and that good faith was disrupted. And then many multiple global agencies. It's not only India. We have given examples of European Union. Aishwarya gave examples of Japan doing it. Various parts, even Russia, we have heard about it. So, I mean, multiple jurisdictions are doing it. But we take example of EU jurisdiction when it comes to GDPR, is from a perspective that, what your data is then going to be put to use to. And that basically should require my consent, is the question which is coming up. And what has been wonderfully also put by Kanu, to whom my next question will go. When you give more data, there is a scientific term which is used as data mining. So I mine the data and find out what particular, preferences you have. And that use of the data mining also has come into question. And therefore, when you see GDPR and all these acts, they've been addressing on various issues is because what your data will be put to use to. Kanu, just to ask you, data mining is another issue that leads to a huge threat to the personal and private data of the users. Each time a person chooses to create a new social media account, the person adds their details such as geographical locations, financial records, biological or medical details, etc., where it's required, adding to this pool. The companies create this pool for the better understanding of the needs of their users, but sometimes they share these details to third parties without consent of the user. This sharing of data may lead to a huge damage to the user. How does the data privacy regulation govern the issue of third-party transaction of personal and private data of the users in this scenario? Your views, Kanu.
I think one thing that needs to be clarified when we talk about data mining would be that it happens at two levels. One level would be, as Aakanksha said, that data mining or data collection at a personal level, where my personalized interests is what I would be bombarded with, whether it is my Instagram feed, whether it is my Google News feed, whether it is my Twitter feed or anything else. I think the devil lies where we talk about data mining at a meta level. It is the metadata which is being mined by these big corporations, through which they are able to create trends. And through those trends, they are able to make a product or basically advertise that metadata and their analysis to advertisers and even to political parties. What is Cambridge Analytica? It was exactly that. So that is where the problem lies. The problem is further compounded, where they almost have this God complex, where they think that they can control the opinion as well. There is a reason why almost all political leaders across the world clamor to meet Facebook today. Why? Because Facebook and Google know more about people today than their own parents, than maybe even their spouses. It is actually a fact. I have a Google Home speaker right now, which might just be listening to what I am saying. So data mining presents those problems. However, again, I think my views might surprise some people, but I'll just put them out there. We need to stop expecting this unilateral benevolence or fairness or principles of a voluntary grant from these private corporations. These private corporations exist for the reason of their shareholders. These private corporations exist to provide you a service in lieu of some consideration in order to make profit. The debate on privacy, the debate on data protection suffers from two fundamental misconceptions, which are there generally in vogue and in terms of what we see in other platforms. Is A, that the government is the villain. The government, as an individualistic point of view, for me, government is not the villain. Government is an important stakeholder through which I can enforce my rights. And number two, that we can enforce our rights against these private players. We can enforce our fundamental rights against these private players. That is something that is completely alien to fundamental right jurisprudence. According to me, individuals need to introspect. If we want these corporations to respect our privacy, Individuals need to introspect, and we need to ask ourselves this question, that are we ready to pay the extra buck for the service that we use in order to attain that privacy? I want to ask the panelists here, I want to ask the people who are watching here, are you willing to pay 5,000 rupees a year to use Gmail? In lieu of the factor that Gmail promises you that it will not read your PDFs or it will not read your emails, which it does, by the way. So that's ultimately it's a business. And again, I say I'm a fan of free markets. So the answer has to lie in a business. The answer cannot lie in a law. And ma'am, why I say that we are too late, or why, you know, an enforcement regime is highly problematic. Ma'am, you know, to overreach the entire regime put in place by our ministry, the only thing that you need, any website being banned or anything, the only thing that you need is a small VPN tool, which a 12-year-old today can download on his phone, which masks my identity, which fools my device and the internet service provider in terms of providing the details from which country I will be accessing. So I may be accessing the internet from India, from my house, but the service provider and the government will think that I'm actually accessing it from Vietnam or from Timbuktu. For anyone can do it. Number two, why I say that we are too late also is that, again, the concept of privacy, it is not a new concept. I mean, this Indian Supreme Court said it, what, in Kharak Singh, 50 years back. The American Constitution said it 200 years back by providing the right to search and seizure, right against search and seizure. The old CRPC had a strong right against search and seizure. It's ultimately a manifestation of privacy. As far as data collection is concerned, data collection used to happen even in the earlier era. As Ankoosh ji said, that, you know, those people would come and they'll make you fill forms and then accumulate that data. That was happening at a very short level. I agree that, you know, Facebook really entered the Indian market, I would say, in 2008, 2009. And emails really started perhaps in the latter part of the 90s. But if we already had a strong background in terms of respecting privacy and respecting data, I think we are too late to the party. Even for that matter, the European Union was too late. I think 2016 was too late. And even till date, what we actually require, according to me, is a global regime is nowhere in sight. It is not even being discussed. The global regime is central to it because you will not be able to enforce it. There will be no enforcement until and unless there is global cooperation. I think that is why I said it. I think Aakanksha said an interesting aspect about where you know, we may have taken it too far when it comes to fake news. I think recently saw a video of Emmanuel Macron commenting on it, and I think it was a very extremely poignant point that he made, that if social media today represents an important part of my freedom of expression, have we given the keys to our fundamental right to a private player? And are we allowing that private player to today successfully, for maybe a year now, or maybe 7 to 8 months, successfully mute a democratically elected leader out of the platform? Is it not an egregious breach of fundamental right by a private player? And what has the most powerful nation or the oldest democracy been able to achieve with it? It's absolutely nothing. So it's a huge problem if the keys of fundamental rights are with these private organizations. Cannot.
And, you know, I mean, just to add to it, since we are on the data privacy part, if these organizations can have access to the data, I mean, you see on the two sides, while we try to balance, I think these organizations will also have to balance it on their part on what is a fair use and what is not a fair use. I think that's a question which poses to everyone in front of us. You know, we had a wonderful session. We had Justice Srikrishna. I'm also privileged to have Ms. Aishwarya Bhati, Additional Solicitor General of India, Senior Advocate, Supreme Court of India. I have Mr. Ankush Mehta, he's partner, Cyril Amarchand Mangaldas, Mr. Abhishek Malhotra, founding partner, TMT Law Associates, Ms. Aakanksha Kaul, Advocate, Supreme Court of India, Kanu, Mr. Kanu Agrawal, Advocate, Supreme Court of India. I think the two sections we had is, one was Justice Srikrishna's keynote speakership, and here the multiple views, a 360-degree view of the data privacy in terms of the disclosure, in terms of the protection, in terms of the interpretation of the law, moving towards the direction that time is of the essence, it's a matter of time, where we move towards a particular law which provides a balancing factor for the data privacy as well as the parameters of data privacy and the bandwidth which is allowed to any corporation, whether it's an Indian corporation or it's a foreign multinational. That's the aspect we discussed about it. You've got a lot of questions. We are just going to restrict to 4 questions. We have 5 minutes with our hand. First question, anybody can answer these
Zameer
questions.
sir, sorry to
Yes.
interrupt you. Before you take up the questions, we
Yes,
have a
please.
lot of live question requests. I'll take just one of them if you permit, sir.
Yes, please. Go ahead. Thank you.
Dr. Srivatsa Krishna.
Right. Please go
Dr.
ahead.
Srivatsa Krishna.
Hi.
Doctor, before you go ahead, I just want to thank you and to thank all the audience for your love and affection. We've got multiple questions. Some we have got also on a personal WhatsApp, and we are very happy to have you. Doctor, please go ahead.
Thank you so much. It was a very, very interesting discussion. But as a Babu, now I'm scared to speak after what Justice Srikrishna said. Unfortunately, Srikrishna will go away after giving his comment. The Babus have to be there to finish the music. So I think I'd like to start by complimenting both Aishwarya ji and Kanu ji, who spoke fantastically. I wrote a piece on this in Economic Times yesterday. I have just a couple of observations, which I don't know if the audience is aware of. First and foremost, it is a well-known fact that 90% of the personally identifiable information, 90% of the personally identifiable information of Americans is already with the Chinese. Number one. Number two, 60 to 70% of our financial data is already with the Chinese. Paytm, don't forget, is owned by 2 large Chinese companies. And by law, in China, they are required to share data when asked. I don't see Vijay Shekhar Sharma giving a lecture on democracy to Xi. He will hand over our data, throw up his hands and come back home. So I think some of it, as Kanu said, we are very late to the party. Some of the data is already gone and there's nothing much we can do about it. The question I have as a civil servant is, when we are administering these laws, and it's something I asked in my Economic Times piece yesterday, if there is a morphed image of any prominent politician as being attacked or murdered, and it goes viral on Twitter or on WhatsApp, it's the bounden responsibility of the elected government to stop a riot from happening, which in our country will happen within 30 minutes. So have we just thrown our hands up and said, thanks to privacy laws, I can't do anything? It's up to WhatsApp and Twitter to do what they have to do. We can't do anything even if a riot happens. Think about it. We need a solution. Privacy be damned if there is going to be a riot happening in the next 30 minutes of something being morphed and going live on Twitter or on WhatsApp, as has been the case in many countries. The other point I'd like to just make and leave you with, President
don't
Biden,
don't forget the hashtags.
President Biden was, he applauded when Trump was taken off Twitter. By all means, if Trump's January 6th tweet was bad, fine, that should have been taken off. But why deplatform him? Today, think of it. If Narendra Modi asks for Rahul Gandhi to be deplatformed, what will all the liberals of India say? Will they agree to it? And will US and President Biden sit back and allow that to happen? They will say Twitter is free speech. And how can government of India deplatform an opposition leader? The very thing that he demanded when he was in the opposition. I don't claim I have answers, but these are some things we should think about. Thank you very much.
No, Dr. Srivastava, I completely appreciate your views. See, these are sensitive matters which you have brought forward. So data privacy is looked upon as whether it will demoralize and destroy democracies. Number one, it's a larger picture we are looking at. It's not about that your Facebook is being watched by somebody. This data exposure can be subject to, destabilizing a democracy is the direction. So we are looking at a larger picture also. One is the use of your data. Number two is whether it should be regulated in the interest of your democracy. And number three, where is your data exposed to is the explicit consent, which should be required from me. So these are the 3 aspects which you have beautifully brought out. Thank you, Doctor, for coming in. Thank you. I will just go to 2 questions now, which are there in my hand. The new rules require the OTT platforms to set up a vigorous three-tier grievance mechanism to address such concerns. Is the government looking to appoint a regulator or set up a special body for grievance redressal and compliances? What is your opinion from regulators' point of view? Anyone can answer that. Any generic view will
Well,
also be.
I want to make a point here. In fact, continuing the thread of what Dr. Srivastav mentioned, I want to just mention about two specific judgments of the Supreme Court. One was on mob lynching. 2 years back, the Supreme Court was dealing with various instances of mob lynching that had come to fore, and many of them had been fueled, orchestrated, planned, perpetrated, and promoted on social media. So there, I think the judgment is by the name of Tehseen Poonawalla, but that judgment had categorical directions, including making sure that, you have where these, the first originator, these messages, I mean, what you can't allow in real world, I mean, we need not wait for the data protection regime to come into place, etc. I mean, our old IPC, the Macaulay era IPC, has sufficient leeway available for this. So specific directions were given in that, judgment, asking for, making sure that you trace out. So if you can't allow that to happen in a real world, it can't happen in a virtual world. The second matter that I'm not sure there's a judgment on that, but that was Prajwala, etc. It was associated with those matters. So I'm remembering, there were video clips of gang rape incidents that were taken, circulated in social media, perpetrated, and promoted like anything. So you can't allow social media in the name of privacy and data encryption to allow them to become safe havens for illegal and criminal activities. So I understand the anguish that Dr. Srivastav just shared. So the regulatory mechanism is a must, because so far what is happening is, now bringing it to the question that is asked, that big tech, whenever you ask them, well, what is your grievance redressal mechanism, every consumer has to be taken to US. They have no grievance redressal mechanism available in India. So you can't expect, see, government is our bargaining tool, because as ordinary citizens, if my image is morphed, if somebody else is using my my data on the social media platform, I will not have the wherewithal, the time, energy, and effort to go seek that redressal mechanism if it is difficult to have access to, if it is beyond my reach. But if it is here localized, I mean the data fiduciary is made answerable, then of course the redressal mechanism is a must. It must happen. Anybody who has to operate in India has to have the fall into the regulatory mechanism and has to have an inbuilt grievance redressal mechanism in India, accessible to common citizens who are the consumers. You are muted.
Zameer, you are on mute.
Sorry. So I think this is all directionally looking at the angle of having the legislation in place. Government has been putting out regulations also to monitor the situation when it gets escalated. But directionally, in the long term, looks out to be a legislative intent which will land up in, which is there already in a bill form, but probably will have the parameters listed and come out as a law. The next question which I have is that the digital era is eased the process of storing information on the devices to an easy access of bank on your mobile application. But is this actually a blessing or a boon in disguise, as bots and botnets are prevalent on social media and are used to steal data, send spam emails, launch distributed denial of service DDoS attacks that help cybercriminals gain access to people's devices and networks linked to such accounts, leading to an unauthorized access of credentials and data and threat of fear of data theft at large scale. Does the current data privacy regulation in India and globally have adequate tools to regulate such issues and bots? If not, what can be done to bridle these issues? Anyone technically? Or I can go ahead.
I'll
Yes,
just say one thing, that I think it is a boon. And that the fact that it's a boon is more evident because of the times we are living in. most of us are buying things online, avoiding going out. You don't want any form of contact, whether it's in the form of cash. And look at today, even your thele wala will be able to accept some form of digital money through a digital platform. So it is a boon, but the problems that have been identified even in this question are problems that can be sorted out. We just need better systems to ensure security of the data we are putting out there. So we can't just blame, according to me, the solution doesn't lie in just saying that using digital platforms and putting your data in your financial data on these platforms is wrong. The solution lies in finding a way to protect that data.
Right, right. So I think what has been also put out when the question has also been put whether it's a boon, we'll use the word user friendly, and we'll try to see that the gap between user and friendly does not expand. So we are coming to that portion of the part where we are saying that these are user friendly things, but the words like data mining, data analytics, artificial intelligence, machine learning, see, these all terms have got to do something with your data. And that's where what we are saying, one is the requirement of a law, a parameter within which it has to be operated, the data can be used. And number two, the consequences if somebody breaches that, or if somebody does not take my consent for using my data in an overreaching manner. So I think these are the aspects we are looking at. So one is the technical aspect of your data mining, your artificial intelligence, machine learning, etc. And second aspect is the legislative intent within which you are protected as an individual or a citizen of a country, like it happens to the EU citizens for GDPR. All right. My last question, sorry, we have been getting good questions, and thank you to all the audience for the wonderful questions being there with us today. This is question on data mining. I had a question on data mining. Is it not necessary to ensure that this is encrypted at rest to prevent anyone from accessing it? Kanu, you want to reflect on something which is known as encryption?
To encrypt it would only protect you when it is being transferred. Ultimately, the problem comes at the level of, as I said, it comes at the level of metadata. That when Google has been analyzing my life as a user for the past 20 years, now Google may encrypt, or WhatsApp may encrypt my messages sent to Aishwarya ma'am. It may not, so that no one can intercept that message from my phone to her phone effectively. But that metadata that I have been talking to madam for the past 3-4 years about matters concerning the Supreme Court or briefing her would obviously be there. And that information itself is marketable, maybe marketable politically, maybe marketable for an advertising agency. So encryption may not necessarily be the answer. Mere encryption is a good start. It's a good start, but mere encryption is not the answer, especially at the level of data mining.
Right. So this is one of the answer. And the second thing, thank you for asking that question to us. There was a recent leak of a film known as Radhe, Salman Khan. Everybody must be aware that it was in the news. The company which was releasing Z5, they wanted to stop this on every social media and messaging platform also. They finally landed up in the Delhi High Court. Delhi High Court has given an order in their favor saying that, the messaging app has to also facilitate to restrict that. There you will find this argument of encryption. There are a lot of debates and arguments which happens that, this is an encrypted material. We can't be able to execute that. But there is a front end and back end. And that's the story we are speaking about. That, when you speak about data privacy and data protection, there are a lot of compliances which are required, and there is an enforceability of a law like GDPR. When there's an enforceability of a law, a citizen of a country gets to know what is data privacy and protection about, what are the parameters within which the corporations have to exist and use my data, and what are the norms where they require user consent to proceed ahead. Of course, when we saw the case of WhatsApp, they said either take it or leave it. but whether it was within the realm of the situation is still to be evaluated. Thank you very much. Very sensitive, very hot topic. We had a privilege of Justice Srikrishna, who was also the chairman of the Committee of Experts on Data Protection Law. We had Miss Aishwarya Bhati. She's Additional Solicitor General of India, Senior Advocate, Supreme Court of India. We have Aakanksha, who is Advocate, Supreme Court of India. We have Kanu Agrawal, Advocate, Supreme Court of India. We had Abhishek Malhotra, who is founding partner of TMT Law Practice. And we had Mr. Ankoosh Mehta, who is partner Cyril, Amarchand, Mangaldas. Thank you so much for being there. Thank you to my lovely audience. It was really a privilege and honor to speak with all the esteemed guests, my panelists, my learned members of the fraternity, and also thanks again to Justice Srikrishna. Thank you to all my wonderful audience. We are coming to here. Thanks again to everyone. Have a great weekend. Thank you.
And thanks to you, Zameerji. You always make it so amazing that you sit for 2 hours and you know how the time passes, you enjoy the conversation. So thank you very much.
It's a
Bye.
privilege.
Thank you so much, everybody.
Thank you so much,
Zameer, Nathani,
everyone.
seeking your permission to end the webinar for everybody.
Yes, please. Thank you.
Thank you, sir.